Today in this video lecture we will discuss the topic Introduction to the Code of Criminal Procedure 1973. So this is the Code of Criminal Procedure 1973. Criminal law is necessary for the social control or social order. It is a weapon for the protection of society against antisocial behavior of some individuals. Law of criminal procedure is inseparable part of the penal law. Law of criminal procedure is inseparable part of the penal law. For example, this is Indian Penal Code, this is penal law. Effectiveness of the penal law depends upon proper implementation of the procedural law. So, effectiveness of this Indian Penal Code depends upon proper implementation of Criminal Procedure Code. In matters of criminal prosecution, the accused person must have a right to speedy trial. Accused person means a person on whom there is accusation that he has committed a crime. The accused person must have a right to speedy trial. Hence, procedural law must provide such machinery where accused is entitled to a fair treatment and trial. In our country, investigation and trial of cases proceed much slowly, and such long delay causes great hardship to the parties. Therefore, time-bound or speedy trial is necessary to avoid such hardship. Also, for the lawbreakers means who has found guilty of commission of offenders. Also, for the lawbreakers, if there is an absence of effective enforcement machinery, then the threat or sanction of punishment which is provided by the penal law will remain empty. Means even though penal law provides a strong punishment for any particular offense, then also in the absence of effective enforcement machinery, such provision of strong punishment, it will remain empty. So there will not be any threat or sanction of punishment. Such empty threats cannot deter means cannot prevent the antisocial elements, and without such deterrent effect, the penal law becomes meaningless. So it is not necessary that to define the offense and provide strong punishment for it, but it is necessary to see how the offender can be found guilty and he be given such punishment. He will be subject to such punishment. The law of criminal procedure is intended to provide a mechanism for the enforcement of criminal law. Without proper procedural law, the substantive criminal law, which defines offences and provides punishment, will be almost worthless. So, mechanism is provided in the procedural law for the enforcement of criminal law. So, in the absence of procedural law, substantive law will remain worthless. The law of criminal procedure is meant to be complementary to substantive criminal law. Accordingly, it creates necessary machinery for the detection of crime, arrest of suspected criminal, collection of evidence, determination of guilt or innocence of the suspected person, and imposition of proper punishment on the guilty person. So, the part of the machinery includes all these things, and provisions are made for it in the procedure law. Our law of criminal procedure is mainly contained in the Code of Criminal Procedure 1973. The provisions of the code are applicable in respect of every investigation, inquiry or trial of any offence under the Indian Penal Code or under any other law. The code has been passed by the Parliament, but as the subject of criminal procedure has been included in the concurrent list in the 7th schedule of the Constitution, a state legislature may, in accordance with the provisions of the Constitution, modify the provisions of the code. Means state can also make necessary amendments which are applicable to that particular states in the Code of Criminal Procedure. Because the subject of, because the Constitution empowers the Union as well as state to make a law on the subject of criminal procedure, as this subject is included in the concurrent list of the Constitution. The modified provisions of the code will then apply to that concerned state when the state makes amendments. It is always proper and necessary to have suitable territorial units for the purpose of administration of judicial system. For that purpose, the entire territory of India consists of states, and for the purpose of the code, every state shall consist of session divisions. Every session division shall either be one single district or shall consist of more districts if districts are small. Any district may be further divided into subdivisions. So, for the purpose of criminal prosecution in the district court is known as session court. For the purpose of criminal procedure code, all offences have been classified into different categories. A general overview of these categories may be useful for better appreciation of the provisions of the code. Firstly, all offences are divided into two categories: cognizable offence and non-cognizable offence. A cognizable offence means an offence for which a police officer may, in accordance with the first schedule of the code, arrest the suspected without warrant. So, in case of cognizable offence, police officer can arrest without warrant. With respect to cognizable offence and non-cognizable offence, there are different procedures under the code in the matters of investigation and inquiry. So, regarding investigation and inquiry, different procedures are there in case of cognizable offence and non-cognizable offence. Secondly, offences are classified into bailable offence and non-bailable offence. The bailable offence means an offence which is shown as bailable in the first schedule of the code. If any person who is accused of committing a bailable offence is arrested and detained without the warrant, then he has right to be released on a bail. So all these things, whether any particular offence under the Indian Penal Code is cognizable or non-cognizable, whether it is a bailable or non-bailable, it is shown, it is expressly shown in the first schedule of the code. So we have to see the first schedule of the code, which shows any particular offence, whether it is cognizable or non-cognizable. or bailable or non-bailable. It is shown in this first schedule of the code. Thirdly, the code classifies all criminal cases into summons cases and warrant cases. Generally, warrant cases are relating to offences which are of the serious nature. A warrant case means a case relating to an offence which is punishable either with death or with life imprisonment or imprisonment for a term exceeding 2 years. So warrant case means a case which is punishable with the imprisonment for a term exceeding 2 years. Another and summons case relate to an offence punishable with the term which is punishable with, if punishable with imprisonment, then it cannot exceed the term of 2 years. This classification is useful. Classification, summons case and warrant case. This classification is useful to determine the type of trial procedure to be adopted in the case. So in case of summons cases, different trial procedure is prescribed. In case of warrant cases, different trial procedure are prescribed in the code. The trial procedure prescribed for a warrant case is much elaborate than the provided for summons case. So in case of warrant cases, procedure is in detail. The main functionaries exercising powers and discharging duties under the code are first police, then prosecutors, that is public prosecutors, then defense counsel who are defending the accused person. Defense counsel means lawyer who is defending the accused person. Magistrate means it includes judicial magistrate also and executive magistrate also. Judges and the prison authorities and correctional services personnel. Correctional services personnel, especially under the Probation of Offenders Act. While the general purpose of criminal procedure is to provide a mechanism for the administration of criminal law, its main object is to ensure for the accused person a full and fair trial in accordance with the principle of natural justice. Unless the guilt is established beyond doubt with the help of evidence, accused person is presumed to be innocent, and therefore it is necessary that to ensure for the accused person a full and fair trial in accordance with the principle of natural justice. Therefore, the trial procedure becomes important part of any scheme of criminal procedure. Another important segment of criminal procedure is the investigation of offence. Investigation includes information as to commission of crime, detection and arrest of suspected offender, and collection of evidence relating to commission of offence. Investigation also includes the process whereby the case is brought before the court for trial. Therefore, it will be considered proper to describe this segment of procedure as the pre-trial procedure. So before trial there are two stages in criminal prosecution, that is first investigation, then inquiry. Then only trial gets started before the court. When the trial is concluded, and the accused is found either guilty or innocent, then in fact the trial procedure comes to an end. So after the trial, that is after consideration of evidence, accused may be found either guilty. If he is guilty, then he is subject to the punishment. If he found innocent, then he should be released. He should be acquitted. However, the code incorporates further procedure for the reconsideration of decisions of trial courts by higher courts. For that purpose, provisions for the appeal and revision are there under the code. So, aggrieved party can make an appeal or revision against the decision given by the trial court. Appeal and revision in the higher court. Higher court, it may include district court, high court, Supreme Court of India. Besides, the provisions for the execution of decisions of trial courts is another segment of the criminal procedure. Execution of decision. For example, trial court has declared that particular offender is found guilty and so he is subject to the punishment. Therefore, for the purpose of implementation of this decision and for the purpose of giving actual punishment to that offender, provisions are made under the Criminal Procedure Code. The code has made provisions for the release on bail of persons who are under arrest or detention pending the pre-trial, trial or appeal proceeding. Provisions regarding bail are important part of the criminal procedure. So releasing suspected from the custody, that is bail. Bail is a security. Releasing person against the bail. However, the code also deals with the matter of public nuisance, that is for maintenance of public order. Though these provisions in the nature of preventive precautionary provisions, like imposition of curfew for the purpose of maintenance of public order. Then matters relating to prevention of offences, that is taking security for keeping peace and for good behavior. Means if the police authorities got information that any particular person is about to commit an offence, the police can take a security from that person for his good behavior. These proceedings are also known as chapter cases. These matters are altogether different from the trial procedure. In case of these preventive measures, this Criminal Procedure Code gives authority to executive magistrates. However, the provisions regarding these matters are important because it indirectly helps to achieve the objectives of the administration of criminal justice system. Besides, there are certain important provisions under the code which confer substantive rights upon the neglected wives, children and parents for their maintenance. So suppose if any man neglect his wife to maintain, then she can make an application for obtaining maintenance in the court, in the criminal court, under the provision of this Criminal Procedure Code. So this is in brief the introduction regarding the Code of Criminal Procedure. we will stop here but continue detailed discussion on various other aspects relating to criminal prosecution in our next video lecture. Thank you.